the Hamptons of Clover Lane versus Deja Giles.
Brian Gerda, again, on behalf of the plaintiff.
Karina O'Hara.
I don't have under 10.
Giles. O'Hara. No response. Would you like to proceed with a default?
Yes, Your Honor, please.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may proceed.
Now, this is a non-payment of rent case. I have a ledger here that including May's rent, there's a balance of $1,545.
Say that number again.
Yes, Your Honor, $1,545. And
buckle up, guys. Today we're going to witness how a routine eviction case instantly turns tense. The courtroom calls Hamptons of Clover Lane versus Deja Giles, but the defendant never responds. With no opposition present, the plaintiff moves for a default judgment. A witness is sworn in, and everything appears straightforward. At this point, it feels like a quick win is coming. But this calm opening is only setting the stage for a much bigger problem that's about to surface.
And 79 cents. There's also $59.04 in service, plus filing and attorney at 55 and 75 respectively, for a total of $1,734.83 due and owing.
What's a month?
Monthly rent, Your Honor, is $1,653 as just the base rent. Looks like they also
$1,653.
Yes.
When did they? So when they were here at April 28th, they owed $3,500 inclusive of cost. When was that paid?
When was it paid? We got a partial payment on May, actually yesterday, May 4th, of $400. I haven't had another payment since that last April 28th date.
Well, hold it, counsel. When they were here on April 28th, plaintiff was claiming that there was $3,325 in rent owing, which means that a significant payment had to come in. If I'm looking at a judgment in the neighborhood of $1,700 now, and May rent has clicked in. And so what I want to know is, when was that payment made?
Yeah, that number that was given at the last hearing, I'm wondering if that included May's rent erroneously.
At this moment, the judge slows everything down and starts comparing numbers from a previous hearing. As an outside observer, you can feel the shift when the court notices that thousands of dollars were allegedly owed before, yet now the balance is suddenly much lower. The judge presses for exact payment dates, and the attorney struggles to give a clear answer. This is the instant where the case stops being routine and turns into a serious credibility issue.
No, it's
That would have brought it.
Michelle. Good morning. This is Michelle, the property manager at the Hamptons of Clover Lane. They brought in payment $1,942.50, and we posted it yesterday.
When did they bring it in?
They actually brought it in last Friday.
The 28th.
Yes.
And when they brought that in, what was their balance?
Their balance.
These numbers still aren't adding up.
$3,638.29.
Okay, hold on. Maybe, and I'm usually pretty good at math, but I have here that they owed $33,25.29 on the 28th. You're indicating they brought to you 1,900?
On the 28th, they owed. Well, by the 28th, our system will have already charged up May rent. It charges it up.
Well, you can't do that.
But
What was
by May
their
28th
balance on the 28th?
On the 28th, they owed $1,705.50.
And they paid how much on the 28th?
1542.50 plus 400. 1942.50.
So they paid the balance on the 28th in April. Why am I here on this case and there's not a dismissal, counsel? And why was it represented to the court on the 28th before Judge Barr that they owed May rent when May rent had not accrued?
I can't speak to.
I'd like an answer.
I can't speak what happened on the 20th, but like I said, it sounds like if their system would have put May's rent in the next day, that is probably where that number came from that the attorney was relying upon. I'm looking at a ledger before me, Your Honor, and that's the information I'm giving to the court. I don't see this payment. So on April 28th. I'm sorry for the confusion this caused, but
I'm not causing it. It's not confusion. There are certain things that have been represented to the court.
Right.
What I'm hearing is that they paid their rent for April.
Here, the judge openly challenges how this case was presented to the court from a third-party perspective. This is the breaking point. The judge questions why May rent was claimed when it had not legally accrued and demands accountability for the misleading figures. Attempts to blame system errors fall flat. The authority of the court is unmistakable, and the tone makes it clear that inaccurate representations will not be brushed aside.
And paid it in April.
If the court would like to pass on this matter, I will speak to my client right now. And if it was paid.
Well, I think you better.
Yes.
Court to pass it.
Judge,
Yeah.
can you recall Moffett versus Ford? We haven't.
And it is.
It is in the township.
Court recalls the case of Moffett versus Ford.
Jay McCurdy appearing on behalf of the plaintiff.
Well, this is in the wrong spot.
I understand.
This
Your
is a
Honor.
14B case.
That's my fault. I apologize to the court, and I will resolve this situation.
Well, it has to be heard there. You want me to, it's probably going to cost you more to try to change venue. I can dismiss it, or I can move for the venue has to be changed. You need to file the paperwork, file the fee. Which do you want to do?
I will dismiss it, Your Honor.
Case dismissed.
In the final moments, a new issue surfaces when the attorney admits the case was filed in the wrong venue. The judge calmly explains the options, making it clear that correcting the mistake would cost more time and money. The matter is dismissed on the spot, closing the hearing with consequences instead of assumptions. Like the video, subscribe to the channel, and we'll see you in the next video.